a decision. All right, the next case on the docket is the Boylan against Rupert case. How much time you want for rebuttal, sir?
I'd like to reserve 3 minutes if I could.
Okay.
May it please the court. Your Honors, my name is Philip Smith with Macklin Burnset. I represent the appellants and also the intervener, Bella Kalina, in this case.
Okay, well, let's talk about the Boylans first. I mean,
All right.
At this point, what standing do they have to challenge the order? As I understand it, they don't own the property. There's no money judgment entered against them. There's a constructive trust imposed on this property. What standing do they have to raise these arguments?
Well, Your Honor, the Boylans were parties in the underlying case, and the court specifically found fraud as to them. And then later, counsel for the appellees decided to do away with the issue of damages to get a final judgment. So they were part and parcel of the case below, as well as alfresco acquisitions.
The remedy that was granted in favor of the appellees was the imposition of a constructive trust, right, on land that the Boylans don't have an interest in, right?
Well, Your Honor, I think that they had interest by way of ownership in alfresco acquisitions.
I thought alfresco deeded the property to this other client of yours, Bella Kalina.
Well, the trial court is contesting that issue and said that that was improper. And that, of course, happened during the course of the proceedings.
I didn't read the trial court's order as saying that was improper. I read the trial court's order as saying that it violated the receivership order, is what. So that whoever took title to the property took it with notice of the receiver's interest in the property. That's the way I interpreted it.
Well, that's correct, Your Honor, but the underlying case of the constructive trust must result from some wrongful act, and that wrongful act was alleged to be fraud as to allegations involving the Boylans and alfresco acquisitions and how this transaction was originally structured.
How did the Boylans, how did they preserve the issues that they now make as argument on appeal? They failed to attend the hearing for the summary judgment, right? So they made no argument to the judge.
Well, Your Honor, it is true they failed to appear, but that's one of the whole reasons that we're here is there was a motion for rehearing that was filed.
Which they failed to appear at as well.
I'm sorry?
Which they also failed to appear.
They did appear through counsel, though. Counsel appeared on their behalf.
I thought that he said to the court that he didn't represent anybody.
Well, respectfully, Your Honor, we were hired to come in after this happened, and we were hired 6 days after the original summary judgment was entered. We made an appearance on behalf of the Boylans and alfresco by way of a settlement agreement with Bella Kalina. At that hearing, we did represent the Boylans and alfresco, and it was a legal argument that we made, and it was basically that we're entitled to, or we would like to request that the court consider a motion for rehearing because we felt like that there was evidence in the record that the court did not consider, as well as we believe that had the parties been properly represented at the hearing, the motion for summary judgment would have been denied. So they did have representation.
Counsel, was the evidence in the record at the time of the summary judgment hearing?
There was some evidence in the record. Now, there was an after deposition taken of the Ruperts, and there was an after deposition taken, or excuse me, affidavit of the Boylans that was not in the record at the time of the summary judgment. However, with regards to the evidence that was in the record, the judge ruled that there was evidence of fraud and summary judgment was appropriate. We know that fraud is rarely granted in a summary judgment posture.
But what evidence was in the record other than the appellee's affidavit? What other summary judgment evidence was in the record at the time of the summary judgment hearing?
There was actually the affidavit of MYRARUPERT, the appellee, was in the record, and that evidence was sufficient in and of itself to prevent the summary judgment. For example, the Ruperts claim that the property was supposed to be put into their name when they had deposited the money. They also claim that they had deposited all of the money that's in there. If you'll notice, attached to the Ruperts' affidavit, you'll see that they only deposited $713,000 and another person deposited $120,000, contrary to the affidavit. Also, the question of who was going to own the property, it's very important to remember that the property was always going to be in the name of Alfresco, even contrary to the affidavit. She states in there, we were going to get that property in our name, and that's what was going to happen.
Yeah, but what evidence in the record at the time of summary judgment was there that said no, that contradicted that?
Well, for example, attached to her affidavit is the emails where he says prior to the transaction, this is not going to go in your name, it's going to go in the name of Alfresco.
But that was initially, there was some conversation where they thought it was going to be in their name, but because the bank won't approve the loan if it's not in Alfresco. I mean, so how does that negate, I mean, they had that understanding. How does that attachment negate the fact of what they had agreed to after the fact?
Well, after the transaction had been entered into and Alfresco had held the property, the parties were, in looking at their emails back and forth, they were in a little bit of a disagreement as to how the thing was going to happen. Now, subsequent evidence that didn't make it into the record suggests that these parties had been doing these transactions before. The Ruperts had entered into a previous transaction, same kind of deal, put the money in Alfresco. Alfresco buys the property, they sold it.
How can we consider evidence that wasn't before the trial court at
Well,
the summary judgment hearing?
Well, that's the point, Your Honor. We came in 7 days after the original partial summary judgment. We went to the court with a motion for rehearing. We presented this information and we said there was an inadvertent reason why there was not counsel. Mr. Jim Ryan testified he thought that the hearing was on the 20th. That's why he wasn't there. Lake County...
But he didn't represent the Boylans, right?
He didn't. His function was to find counsel, and in that evidentiary hearing, there was a lady who testified that she was engaged to be the counsel, but they thought the hearing date was on the 20th. And so there was, under 1.530, the court, recognizing that even Lake County records indicated the hearing date to be the 20th, should have allowed for the evidence to be at least considered in favor of the Boylans and Alfresco.
Did the court, though, make a judgment call on credibility and determine that they believed that the appellee's counsel was more credible as regarding the dates of the hearing and notification and all of that?
Well,
We can't go back and sit in the trial court's position in terms of judging credibility.
I understand, Your Honor, and I think that's exactly right. However, what we're talking about here, though, is the rights of the parties. And when we find that there was a mistake, and we find that 6 or 7 days after the fact...
But counsel, that begs the question. I mean, I think Judge Berger's point is if the trial court makes a factual finding based on competent, substantial evidence that there was no mistake. There was no mistake.
Right.
That the attorney, when setting aside Judge Torpy's issue, that the attorney didn't represent your clients. That same attorney, there was evidence that the trial court accepted that there was a discussion of the proper date, and the notice of hearing contained the proper date, notwithstanding what might have been on the online docket. Wasn't the trial court appropriately made the weighing of the evidence and made the determination?
I think that's absolutely right as it relates to section 1.540, but we also came before the judgment was final after its 15 days, and there was a motion under 1.530 and the standards being much less stringent. And the court really never considered the 1.530. In fact, required a 1.540 hearing and made these findings. So we think while those findings were made, the court should have considered under 1.530, because this was a timely 1.530 motion, the court should have listened to at least the evidence to determine if that evidence would in fact be something it should have considered in the record.
But
and
does
again,
1.530 contemplate, if your argument is that the trial court overlooked evidence, doesn't that contemplate evidence that was actually before it, that it overlooked, as opposed to not being submitted at all?
well, that's exactly right, and that's why we're saying that there was evidence overlooked, Your Honor. The burden of proving absence of a genuine issue of material fact is on the movant. Until the movant has met this burden, the opposing party is under no obligation to show that issues need to be tried, and that's the Hall v. Talcott case. So here, we look at the record evidence that was before the judge, even absent anything else from the Boylans or Alfresco. And let's look at the issues. The Ruperts argued that they thought the property was going to be purchased in their name. Well, we know that in the record, prior to them putting money into the Alfresco account, they were told that it would not be that way. They were told that in their affidavit of Myra Rupert, she shows that there was a contract for buyers for the property. She also shows that there was the HUD-1 that showed that the property was going to be purchased in the name of Alfresco. And what did they do? They knew all of this, and they went ahead and put the money in Alfresco anyway.
What are you saying, that the Ruperts have no interest in this property?
What we're saying is that that is one of the things that's in dispute, because the nature of the transaction is in question.
Is it disputed that the Ruperts provided purchase consideration for the property?
Well, they provided some of it, but they did not provide all of it.
Is it in dispute that they provided a substantial amount of the purchase consideration?
There is no dispute that they put a substantial amount of money in Alfresco acquisitions. Now, was that money in the form of a loan? Was it in the form of an investment? What exactly was the nature of the transaction?
So the Ruperts, because of the deed out of the Boylans to the other client of yours, and now a deed to somebody else, the Ruperts are going to get beat out of their money if you win, right?
Well, it's even before that, Your Honor. The quitclaim deed is but one issue. The second issue...
Are the Ruperts going to be entitled to some interest in this property if one or more of your clients prevail, or are they just out their money?
Your Honor, if it is in the form of a loan transaction... Just
out?
Well, no, they're not out. They have an adequate remedy at law to collect on the note. Is it collectible? I don't know.
They have some sort of a right to collect on a debt, but they don't have a right to any interest in the property, as you're arguing.
If the transaction turns out to be a loan to Alfresco to buy this property, and there was no perfected security interest in that property, then we have to go by property law rights. And Bella Colina, in addition to the deed, received a judgment in the amount of $3.7 million, recorded that judgment, and that judgment was recorded as a lien against real property in the name of Alfresco, even before the court entered its order on summary judgment as to the constructive trust. And it is very important to understand that with regards to the lis pendens that was filed by the Ruperts, that lis pendens expired.
It did, but the receivership wasn't expired, and there was an order that there can be nothing done with this property while it was in the receivership, and it was transferred. Bella Collina received it through Alfresco's transfer during the receivership in violation of the trial court's order.
Well, respectfully, Your Honor, the transfer by way of the quitclaim deed, perhaps the court says that's meaningless, but it doesn't do away with the judgment lien that is in the property records, and we know that the receiver
But
holds
counsel,
it for the
That
benefit.
judgment lien was subsequent also to the order appointing receiver.
But the order appointing receiver was an appointment of a receiver based on waste of the property. It was not based on, nor is there any finding in the receiver.
Why does that matter? Why does, if there's an order out there that says nothing can be done with this property absent authority from the court, then why does it make any difference what the receivership was for? I mean, you can't transfer, if you can't transfer the property without court order, you can't transfer the property without court order. And in this case, the evidence shows that it was transferred without court order.
Well, first of all, Your Honor, the judgment lien was recorded as a matter of course and a matter of practice. So Bella Collina's rights under the judgment lien occurred in the ordinary course of
They
business.
had certain rights, but they didn't necessarily have rights at that particular time to this piece of property.
Well, we understand, but neither did the Ruperts at this particular point
It
in
was
time.
under litigation at that particular time, and there was a receivership.
Right, and the lis pendens had expired, so their interest in that property was no longer perfected.
Well, wasn't the appointment of the receiver to protect their interest in the property?
Respectfully, no, Your Honor. The appointment of the receiver was to protect the property from waste until there was an adjudication as to whose property it was. In fact, if we look at the order on receiver, this order appointing receiver had a couple of issues. First, in paragraph 8 of the order, it says that the order shall be effective when the receiver files a good and sufficient oath of receiver, whereupon he shall take fully and faithfully to perform his duties. There was never an oath of receiver. When does this become effective? By its
It
own...
was argued to the trial court?
Yes, Your Honor.
Where and when was that argued to the trial court?
That was argued to the trial court in the motion for rehearing.
But I don't think that issue was argued in the appellant's initial brief, was it?
Well, it wasn't in the appellant's initial brief because the issue of the receiver wasn't raised because we didn't need to raise it. They raised it in the answer brief, and then it was raised in the reply brief.
Well, but if you're challenging the trial court's order, don't you have to assert in your initial brief every issue that you believe was erroneous in the trial
Well,
court's
and in fact, I believe that it was raised with the issue of the intervenor, Bella Collina. It was in one of the briefs, for sure.
You're well into your rebuttal time. Did you want to say?
Yes, Your Honor. I'm going to save the 2 minutes if I could.
All right, thank you, sir.
Thank you.
May it please the court. I'm Derek Schroth. I represent Mr. and Mrs. Rupert. On September 23rd, 2011, they paid $913,100.29 for the purchase of this property. Opposing counsel tries to show that some of this money came from another source. If it did come from another source, those parties are not before this court, nor has any issue been raised by anybody who may have contributed additional funds to the purchase price. That is undisputed, and it was a finding of fact in the trial court's order regarding the denial for rehearing that the Ruperts paid $913,100.29 for this property. The appellants in this case abandoned the property after litigation. They didn't try to put it up for sale. They didn't convey it back to the Ruperts. They abandoned it, and they left the country. And because of that, the Ruperts filed a verified motion for a receiver, and the court appointed the receiver suggested by Bella Collina's president, Randall Green. Randall Green suggested a receiver to the Ruperts, and the gentleman who was suggested, the court eventually approved. The court ordered the receiver to take immediate possession, which the receiver did. At no point did they object to it. They didn't file an appeal of the receivership order under 9.130D. And the purpose of the receivership was to protect the Rupert's interest. The court in its order specifically found that the Ruperts had an equitable ownership interest in this property. It was to protect their interest. No one else at that time asserted any other interest in the property. And what's interesting about that order is it set forth a procedure for claimants. And the order says any claimant claiming a specific lien on the property that's in receivership must come before this court and file a claim. After the receivership order was entered, Bella Kalina got their judgment. And then they filed their claim pursuant to the receivership order. They knew the receivership existed, and they invoked the procedure set forth by the court and filed their claim through a motion to intervene, and alleged in that claim that they had a judgment, but that that judgment was inferior to the Rupert's claim. Recognizing their inferiority, they did that in the claim they actually filed
He
with the court.
alleged that it was inferior or superior?
Acknowledging its inferiority, they specifically said that their claim was, quote, subject to the Rupert's claim. They didn't say we are inferior, but they did say subject to the Rupert's claim in that document represented to the court. In March of 2014, Randall Green met with the Ruperts, and he told them, you need to deed me this property because, quote, you do not want to jump into our shark tank, period, unquote. That's what he told them. The Ruperts then asked their lawyer to file a motion for summary judgment, which their lawyer did. It was properly noticed. The appellants had notice, and the hearing took place. But prior to the hearing taking place on June 6th, there was a discussion between counsel, the Ruperts' counsel, and another gentleman who says that he didn't represent anybody at the hearing. That's what he said. And that gentleman, in that conversation, confirmed the hearing date of June 10th and told Mr. Alexander, I'm not going to the hearing. After receiving notice of the hearing on April 28th, so this is about 2 weeks after getting the notice of hearing for the summary judgment, Bella Kalina participates in this violation of the court's order and goes to Alfresco and through a power of attorney gets a deed. They obtain this deed in violation of the court's order, but they tell Mr. Rupert's and Mrs. Rupert's counsel, we're not going to record the deed. We have this deed, but we're not going to record it. 7 days later, they withdraw their motion to intervene, and they say and represent to the court, we're withdrawing our motion to intervene because we have a deed now. But they also represent in that withdrawal, again, subject to the Rupert's claim. So they're acknowledging the inferiority of their claim to this property because the Ruperts had already established a receivership order for their protection long before that. Although Bella Kalina's lawyer represented to the Rupert's lawyer he would not record the deeds, they recorded the deeds on May 30th, 2014 in violation of the court's order. And now Randall Green and his wife, the president of Bella Kalina, live in the home and have and continue to enjoy it as their personal residence. It's important to note that the consideration reflected on the deed is $10. You have these conveyances, and that's what they've represented to the state for taxation purposes. That's a $10 transaction. At the summary judgment hearing Mr. Alexander attended, there was ample evidence in the record to support the court's conclusion, and the court's conclusion is very simple, that the Ruperts should own the property they paid for. That is the conclusion. And this court must confirm a correct conclusion if it's correct for any reason. The reason it's correct, and I understand the arguments as to fraud, that fraud is virtually impossible on summary judgment, but the court had another basis for its ruling, and that was unjust enrichment. And that unjust enrichment decision is correct. It was their money, they paid it, the defendant was unjustly enriched by using it to put the title of the property in their name. And so the court imposed a constructive trust. And there's another reason it's correct, is because they did not raise this issue in their initial brief either. They did not challenge the court's decision on unjust enrichment. They did not raise that in their initial brief, and this court should affirm. Another reason, as you pointed out, that you should affirm is the receivership order was in place, and the court used the receivership order as its basis to determine its conclusion that the Ruperts should own the property they paid for. And that was not raised in the initial brief, and it was not raised in the brief by Bella Collina because this court ordered that Bella Collina's argument is limited to only whether it was a party under the Liz Pendant statute, 48.23. So it was not raised in the initial brief. But even if it had been, it's the correct decision. This court has a long-standing recognition of receivership law. In the Sunland case, this court stated that a receiver is an arm of the court, and the funds in its possession are as though they were in the hands of the court and held for the benefit of all lawful claimants. And you cite two cases that deal with judgment creditors, the same situation that's here. One of those cases that cited, Modart, determined a judgment creditor cannot obtain interest in receivership property. Just cannot be done. Another case cited, the Union Carbide case, cited in Sunland, a judgment creditor, quote, is powerless to perfect its lien after appointment of a custodial receiver. Case law is very clear, and again in Sunland, you've stated, no creditor may obtain preference by any lien rendered subsequent thereto, even if the suit under which the judgment lien is acquired was commenced prior to the date of the order appointing the receiver. And this is the emphasis in the original opinion. Once a receiver is appointed for a business or person, as was done in this case, the entity loses the power to transfer its property subject to receivership. The trial court's decision was correct. The property in receivership could not have been transferred. Not only does it violate the court's order, but as an operation of law, it could not have been transferred once it was in the hands of the court, placed there for the Rupert's benefit. There was a contention that opposing counsel made that an attorney had testified at the hearing that she was confused as to the date and may have been operating on behalf of one of the appellants. Page 65 of the transcript from the proceedings on October 1st, I specifically asked the attorney, Allison Strange, on whose behalf were you acting? Because the argument was that she may have been hired by the appellants. Her answer was, it was Mr. Green's behalf. Not the appellants, but Mr. Green, the party who now possesses the Rupert's property with his wife. So we would respectfully request that you affirm the summary judgment. We also request that you affirm the court's denial of the motion for rehearing and motion for reconsideration. The court denied both. The court entertained both motions, and the court denied both primarily because they didn't show up to the hearing. There was no testimony from the appellants that there was a mistake. The only testimony of mistake was from Mr. Ryan, who says he was not representing a party to the case. That was his testimony. And more importantly, the judge found that Mr. Ryan's testimony was less credible than Mr. Alexander's testimony. And the trial court, as you pointed out, is the one who sat there, weighed the evidence, judged the demeanor of the parties, determined the credibility, and made a finding of fact that there was no mistake in this case. So we respectfully request that you also affirm the court's order denying the motion for reconsideration. And I thank you for your time.
Okay, thank you, sir. All right, you have a little over 2 minutes left, sir.
Thank you, Your Honors. I want to point out the Liz Pendon statute because I think it's instructive in this case as to the rights of the
It says it
Ruperts.
expires, right, after a year.
Yes, it expires, and then any person acquiring for value an interest in the real or personal property during the pendency of an action described in subparagraph 1, which
Counsel,
is...
let's talk about that. Isn't there evidence in the record that it wasn't acquired for value?
Absolutely not, Your Honor.
$10?
Any record evidence of this case would suggest that the deed came as part and parcel of a settlement for a $3.7 million judgment that was recorded in the real property records of Lake County. Absolutely plenty of consideration there. And when we...
Is that something the trial court could make a determination as to whether in fact that was a bona fide good faith settlement?
Presumably, it can, Your Honor, and determine the property rights of Bella Colina under, if not the quitclaim deed, but certainly under the judgment lien, because the judgment lien was recorded, and when there's a lapse in the lis pendens, the statute says that the party to the proceeding shall take such interest exempt from all claims against the property that were filed in such action by the party who failed to record a notice of lis pendens, or whose notice expired or was withdrawn or discharged, and from any judgment entered in the proceeding, notwithstanding the provisions of 69501, which has to do with conveyances, as if such person had no actual or constructive notice of the proceeding or of the claims made therein or the documents forming the cause of action against the property in the proceeding. So you see, the lis pendens statute's very clear. Once it expires, the parties to that proceeding do not have an interest, even after a judgment is entered, because the lis pendens expired and the person who recorded the judgment lien has a now superior right. That's why lis pendens have to be in the property.
You can't just keep talking, you're out of time, sir.
I'm sorry, say it
Your
again?
time has expired. Thank you.
Thank you, Judge.
All right, court will be in recess.